numerous pictures. I believe names of the video, and then at that point we contacted the DA's office and let them know what we had, and then Trooper Stone, I believe on March 15th, delivered this evidence to Mr. Swope.
And the frame by frame, did you ever see it on a high resolution screen or at the technical school? Did you ever see this video?
I have not myself, no sir.
Sure. But there was evidence in your investigation. Now let's talk about what it is that made you think that somebody came out that driver's side front window or passenger side front window. Was there anything particular you saw in the photograph?
In the beginning of this case, when we was documenting all the evidence, of course we do our normal thing and take hundreds to not thousands of pictures. So I mean, we're just documenting evidence at that point. It was never came up that Miss Lindsey was sitting anywhere different. And the fact that she had been ejected was a factor in the case, but not a factor of a contributing factor of how the wreck might have occurred. And then once Trooper Stone discovered this and contacted me, and then we started looking at the evidence, then it started coming together that, well, if she's sitting where we're saying she's sitting, then this could be a factor in the case.
Now, this meeting that you had with the district attorney and the two assistant district attorneys, were you ever asked to memorialize that down into a report?
No, sir. We're not. We just, like I said, just the pictures and the videos.
And the pictures and the videos were delivered to them at some point in time?
They were, like I said, on September 15th, we had already delivered the videos, and then the meeting didn't occur until March the 28th. Or not, I said March 15th, I'm sorry.
All right, gotcha. So they were delivered March 15th, and there was discussions with you, and you explained the theory that you thought Miss Lindsey might have been sitting in the front seat or sitting in between the two seats. Is that fair to say?
I would say it's fair to say the March 28th meeting was myself and Trooper Stone. I had contacted Mr. Cranford and told him we'd like to meet to discuss this new evidence. So I would say that meeting was for that purpose.
And how was your theory met by the state? What did they say?
It was discussed. I mean, from the five of us at the time were discussing just discussing the evidence that we had found. And then at some point, Mr. Cranford, said to us, he expected us to testify to what the evidence leads us to believe in the case. And then it was up to them, the two of them, to prosecute the case, and that this evidence would be totally. The evidence had been turned over to y'all already. So that was. Then he left the meeting at that time. So then it left me and Senior Trooper Stone and Ms. Myers and Mr. Swope to continue discussions. I can't remember how long we continued to discuss it, but we did.
So on March the 28th, you believe that the discovery had already been given to the defense. Is that fair? Is that what you told?
As far as I know.
Now, as far as discussions with the defense, were you ever instructed or encouraged not to discuss anything with the defense unless the DA was present?
I wouldn't say that. No, sir.
What would you say?
But are you asking about when you called to interview me?
Yes.
Back during the Super Bowl, I was attached to the Super Bowl for, of course, because it was in Atlanta. You contacted me and asked to have a sit-down interview pre-trial over my testimony. And at that time, I told you I'd have to get back to you on that. And I'm at headquarters for the Super Bowl, so I have all my command staff there present. So I immediately went to them, being that this case involves a former state trooper, and said, look, I've been contacted by the defense, what do you suggest my options are here? And they said, well, you need to contact the DA's office and run this by them. That'd be their call. So that's what I did. I contacted Ms. Myers, and we had a conversation, and she did not tell me that I could not talk to you. She said that she preferred that she be present during the interview if I was going to give one. And at that point, I did not have to contact you back because Ms. Myers was meeting me the next day, and she said she would take it up with you. And then at that point, I never heard anything more of it.
Fair enough. And just so it's clear, the Super Bowl duty was in February. That was before the meeting in March or anything before the video was enhanced.
Yes.
Okay. That would have been the first weekend in February. Is that fair?
That's fair.
Okay. And as far as the video being enhanced, did you have anything to do with that? Was that done by Trooper Stone?
No, that would have been done by the other members of SCRT along with this Mr. Gary Gibbs at Southern Crescent Technical College. I was not present there.
And just so we're clear, any sort of notes or memorandum or memorialization of y'all's meeting with the district attorney's office, would you as a trooper would not have done that, and you didn't do it, did you?
No, sir. No, sir. I did not, and none of my members did. Me and Senator Trooper Stone was only two present, and we did not bring anything to the meeting, anything extra that we had already delivered to them on March the 15th.
Did you write anything afterwards?
No, sir.
That's all I have. Thank you, Mr.
Go ahead.
Sergeant Barrow, when we had that meeting, about half the time you were there was spent trying to find a computer to view the video, right?
That is correct.
And we didn't really start discussing it until we got it up on, I think it was my laptop, right?
I think that is the only time that I've even seen and I don't even know if that one you're talking about was even enhanced. We're on the way, after we finished the meeting, we're on the way out, and we stopped by your office. You walked us to your office, and we put the video on. I'm going to say we looked at it for maybe a couple of minutes.
And in fact, the disc that y'all brought that day to that meeting with the enhanced video, we never got to work that day, did we?
No, sir, we did not. Trooper Stone had, I believe the program's called Adobe Premiere, which allows you to slow down the frame rate, and you can click through in a virtually just minute frame rates, real short distances, which we used at the Southern Technical College. And he attempted to get it loaded onto a laptop, which, as it was working, he said when he left that morning, but when we got to y'all's office and he started trying to load the program, I mean, he spent, I don't know, I'm guessing 30, 45 minutes trying to get that program working, and we finally just gave up on it and started discussing the case.
So the video that y'all enhanced at that meeting, you didn't see, Stone didn't see, nobody from the DA's office saw it, correct?
Not that day, no. So the only video we saw that day was the one that you showed us in your office, and I don't know what program you had it on it when you showed it. If you told us, I don't recall, but.
But that was the unenhanced video, correct?
Correct.
And y'all discussed your theory of this, right?
Correct.
And in that theory, did you participate in coming up with that theory, or was that Trooper Stone's theory?
Trooper Stone was the one that brought it to light, and then we as the skirt team started discussing the theory, and then all of a sudden it was pretty obvious that she was not sitting in the back left.
Okay. And you would agree with me, though, part of the questions that we as the DA's office asked you were, can you say exactly where she was sitting?
That's correct.
And were you able to tell us exactly where she was sitting?
No, sir. We were able to tell you where she was not sitting. We were not able to tell you at the exact point where she would have been sitting in the vehicle. We could just give you a general area.
And you would agree that the theory had, she could have been in the front passenger seat, she could have been in the driver's lap, she could have been sitting on the center console, she could have been sitting forward of the center console, she may have been leaning forward from the back seat with her head leaning forward, she may have been shoulders past the front seat. There was any number of possible theories that y'all said could be possible.
That is correct.
But there was no definite, she sat here, she was in front of a window or anything of that nature. Is that correct?
That is accurate.
And let's talk about being contacted. You said you were contacted the first weekend in February to speak with Mr. Pilgrim. Mr. Pilgrim contacted you around the first week of February.
Oh yeah, it was sometime that week I was at the Super Bowl. I was actually in the Georgia State Patrol headquarters. That's where we were staged. So I was there when it happened, and like I said, the whole State Patrol command staff's there. So I immediately went to them within a minute of talking to him.
And between September the 26th of 2015 and the date this trial started last Monday, which would have been the 13th, did anybody from Mr. Pilgrim's office contact you and walk through your report, your case, your theories of the case?
No, sir.
Did anyone from Mr. Pilgrim's office call and ask you, other than in early February, if you were willing or able to meet?
Other than that one time, no, sir.
Judge, you can have one moment. Judge, that's all I have.
Drew Barrett, would where Mrs. Lindsey have been seated in the car as an accident reconstructionist, would that have possibly changed, I won't say your thoughts, but your ultimate opinion on this crash?
My opinion's pretty much been maintained, stayed the same throughout this whole case from the beginning to end. That's just another factor that we would have added to the case, and the reason why we did so.
And let me ask you that factor that she would have obstructed the driver from seeing?
If she's sitting or leaning through the middle console area or sitting in the front passenger seat, yes, she would have obstructed the driver's view, and possibly distracted his view from making this turn.
And what has been your opinion on this case?
My opinion on this case is more than the factor that Trooper Scott was speaking. It's also a factor that Mr. Wall failed to yield the right of way by never attempting to slow or stop.
That's all I have.
You would agree that at the point where you believe Ms. Lindsey's head was in the front portion of the vehicle, you would agree at that point?
Some portion of her body, yes.
You don't know if that occurred as the turn was being made, after the turn had started. The point where it's believed that her head is seen is moment of impact, or just the moment prior to impact, right?
That's correct.
Okay. So there's nothing to say she was leaning forward when Mr. Wall checked to see if the road was clear.
There's nothing to say, like you said earlier, how she was sitting, where she was leaning, but except the evidence to the fact that she is somewhere forward of the two front driver's seats, or at least more of her body than mine.
At some point in the moment before the crash.
Correct.
So, and you can't say whether that she obstructed Mr. Wall's view when he decided to start the turn.
No, you can't see that to be able to tell.
And that would just be speculation at that point, whether or not he was in fact distracted, or whether or not his view was inhibited.
I would say that, yes.
Judge, just one moment. And I think Mr. Pilgrim asked you this, but this didn't change your opinion on the nature of the crash, did it?
No, sir. I still have the same theory that I just mentioned to him, and just added to the fact that it would be another factor in the case. And that's why we addressed to have the meeting with y'all.
Judge, nothing further.
Nothing further, Your Honor, that's to be excused.
You can step down and you can be excused.
Thank you. Your Honor, we would call Trooper Brandon Stone. Yes, sir. And again, just for the record, please state your name, your occupation.
Brandon Milestone, Senior Trooper, Board Step Trust Group.
Mr. Stone, we are having this hearing while the jury has been recessed for a while. And we are interested in a meeting or meetings, you tell me which, that you may have had in the district attorney's office leading up to this trial? Do you recall having meetings with them?
Yes, sir.
Okay. Do you remember the dates?
The exact dates, I know we had one on March the 28th.
Okay. That particular date, March 28th, where was that meeting held?
Carroll County District Attorney's Office.
Who was present?
Ms. Meyer, Mr. Swope, and the District Attorney himself.
Mr. Cranford.
And yes, and Sergeant Barrett.
And do you recall discussing in that meeting about a theory you had about Miss Lindsey and her position in the vehicle?
Yes, sir.
What was it?
That there is a probability that Ms. Lindsey is in the forward seating position of the vehicle.
Okay. And what made you believe that?
Prior to, I believe it was March, I believe the trial was supposed to go March 18th, or that's when the motions were.
Yes.
I was preparing for trial and had a colleague go over the case with me, make sure I had everything taken care of.
Yes.
And he questioned the ejection of Miss Lindsey. When I started looking at that, it landed me that there was something different about why she was ejected. She was the only one ejected from the vehicle. Looking at the video, we were able to take the video to Southern Crescent Technical College and have the audiovisual department enhance it by lightening it so you could see better, to see if we could see right before impact who was sitting where.
Yes.
And right before impact, you do see what appears to be a blonde head, which Miss Lindsey was only blonde in the car. Everyone else had dark hair. And that blonde object, or light object, colored object, is in the forward seating position, meaning somewhere in front, the driver's area, okay? Now, you can't tell exactly what we're looking at here, but it is a bright object that is lighter in color.
Did the district attorney's office ask you to take this video to the Southern Tech, or is it something you did?
No, it's something we did on our own. Once we actually downloaded or burned a copy of that video, along with some snapshots that the audiovisual man at Southern Crescent took from the video, and took it to the district attorney.
Was there also a Snapchat video that you had downloaded, or?
I did not download the Snapchat video. I'm not sure where that came from. It was part of the case.
Okay, part of the case, but it was not something you had done?
No.
Okay. So you had this conversation with them on the 28th. What, if anything, are you told by the district attorney's office in this meeting?
Okay, well, on the 15th of March of this year, I took the case to Mr. Swope, or I'm sorry, the video to Mr. Swope. And then we had motions that following Monday, and the trial was set for this week, or last week. On the 28th, myself and Sergeant Barrett met with the district attorneys and ADAs in Coweta, and we talked over the evidence that we had found. And that was it.
Were you given any instruction about making a record or report, memorializing this meeting with the DA, or your new theories or findings?
We simply talked over it, and they had possession of the video.
Okay. And any writings that would have been done, did you do any writings whatsoever following this meeting?
No, sir.
And let me ask you, with Miss Lindsey being in the forward position of the vehicle, would that have necessarily changed your opinion, as a expert witness or reconstructionist in how the accident actually occurred?
How the accident occurred was simply what you see in the video.
Yes, sir.
The question is where the driver of the Nissan, what they could see. And of course, if someone is there and that to their right as they're making the left turn, it's going to hinder them to see.
Okay. And as their accident reconstructions, which testified in before written trial, you testified earlier that you had, would that be a factor that you would consider important?
It could be, yes, sir.
And it was a factor that you thought was of enough relevance that you brought it to the VA's attention the 28th of March?
Correct.
Okay. Now, just to be fair.
Actually, it was on the 15th of March.
Sorry, 15th of March. meeting was the 28th. Is that
Correct.
And just to be fair, we as a defense company, we never contacted you, did we? We never called you before the trial?
No, sir. First day we talked was during motions.
Correct. And, let me ask you this, why was it important that you got the disc to Mr. Swope when you did?
On the 15th?
Yes, sir. Why did you think that?
Prior to that, the trial was set for sometime in March, and I believe where we have to turn over evidence, the word leads me now, discoveries was due on the 15th.
And so you got it to him because that was an important date to get it to him?
Yes, sir.
Now, let me ask you, when you were going through this video, let me ask you, did you ever watch the video with the ADAs? Did you ever see the enhanced video that we talked about?
When we went to the meeting on the 28th, we could not get the video to play on our system.
Yes, sir.
And the system that the technical college used is whatever program that was, I believe it's an Apple program, was a lot more advanced than what we have. We couldn't get that video to play, but we did watch the in-car camera video that was not enhanced.
Okay. And when you watched that video, did you and I won't ask what Trooper Carroll did because you can't say, but did you attempt to explain to the district attorneys what it was you were looking for in that video, as far as you mentioned the blonde hair or the blonde head?
Yes, sir.
Would you explain it? Did you tell them that's what you were looking for in the video?
Yes, sir.
Okay. And is this something that, without your explanation and in your opinion, is this something that somebody would see without an explanation? Hey, look at the blonde head.
Very possible, no.
And how long have you been doing this?
22 years, 21 years.
And how many videos have you watched?
Thousands, yes, sir.
From all different angles, cars,
Yes, sir.
passerbys. Were you ever asked again by the district attorney's office about your theory about her being seen in the front seat?
After the meeting, we went in, no, sir.
Up
Not that recall.
until, did anyone ask you up until me yesterday when I called?
No, sir.
Thank you, sir.
Yes, sir.
So Trooper Stone, when we met in our office on, I think you said 325, or 328 or 328.
Yes, I believe it is.
Y'all brought the enhanced video,
Yes, sir.
and we couldn't ever get it to work, right?
Yes, sir.
Tried it on your computer,
Yes, sir.
tried it on my laptop,
Yes, sir.
I think my desktop, I think we tried a couple different, and that just never worked, right?
Well, yes, sir, we can never get it to play that I have.
And at some point that day, we did watch the original unenhanced video,
Yes, sir.
and we never reached agreement about whether you could see anything in there, right?
Reach an agreement as to,
You and I didn't see the same thing in the video, did we?
no, sir.
Okay. And we talked about when you believe Miss Lindsey might have entered the front. I'm going to call it the front compartment. Is that the right term?
The front seating position.
Okay.
Not in the back seat area, but the front seat area.
Okay, so in the front seat area, and I believe you told us that you couldn't say if she was sitting in passenger seat, the driver's seat, center console, for the center console, or maybe she was even just leaning forward, right?
Correct.
Okay. And were you ever able to determine if and when she would have entered that front seating area based on your analysis?
When she entered it?
Yes, sir.
No, sir. I mean, she could have done way down the road.
She could have done it a long way back, but
Yeah.
she might could have done it after the term was initiated, right? If she was leaning forward.
She could have.
Okay.
That's not something
It would be speculation to guess when she entered that front area, right?
in the video, when she did, I can tell you in the video that it appears that she's in it just seconds before the crash.
Right. So
Yeah.
we know if your theory is correct,
Yeah.
her head is in the front area, moments before the crash.
Yes, sir.
But we don't know when her head entered that front area.
No, sir.
And it would just be speculation to try to determine when.
Yes, sir.
So she might have, after the turn was initiated, leaned forward into that area.
Could have been. Yes, sir.
Okay. And you indicated, I believe you indicated to us that it's a high probability she was there, not that you were certain she was there. Is that fair?
Well, I mean, I can't see her face in the video by no means,
Okay.
but you can tell there's something.
I liked her splotch
Yes, sir.
in the, I guess, through the front passenger window.
Yes, sir.
Did anybody ever tell you couldn't speak with?
Can I just ask, where does that come from, the patrolman video?
Yes, sir. Yes, sir. It comes from the patrol car.
Okay, thank you.
Did anybody from my office or from your command or anybody else ever tell you not to speak with Mr. Pilgrim or his office?
No, sir.
Have you had the occasion to speak with defense attorneys in preparation for a case, in cases other than this one?
I've never talked to him. No.
Okay. Have you ever been told you're not allowed to?
No, sir.
Have you often been told they might contact you?
Yes, sir.
And this wouldn't go to how Mr. Wall operated, the physical control of his vehicle, right?
Yes.
Yes, or it would, or
No,
yes,
I
or
mean, what is your question?
Sorry.
I apologize.
Sorry, whether or not Ms. Lindsey's was in some position in the front area would not go to how Mr. Wall physically operated the vehicle, right?
I can't say that. I mean, in the video it appears he makes the turn without someone stopping him or physically, so
It goes to a question of
visibility.
visibility.
Yes, sir.
Okay. And are you aware that a victim's negligence in a strict liability proximate cause case is irrelevant?
No, sir.
You weren't aware of that?
No, sir.
Okay. Sorry, Judge. Judge, if I may have a moment.
We'll take a 10-minute recess.
Thank you, Judge. You're clear to stay on the stand. So now just take one.
Record button won't turn on. My record button won't turn on. Oh, there it goes. There it goes. Turn that freaking mic on. Huh? You want? Okay. Yeah. I did it yesterday and fell back in that chair. You hit that mark, when you turn on, you got 1, 2, it goes 1, 2, 3, electro. If you hold this electro too long, it goes off. And that's what it did. I thought it was steady. It's my fault.
It's just an extra door. They just put it there so that we can sit on this road. Well, they let us just observe. I do now.
Stop watching this minute. Start talking.
remain seated. Court will come to order.
All right, go ahead.
When was the first time you were contacted between Monday and today to discuss this issue?
Yesterday.
At approximately what time?
Somewhere around 6
In the PM or the
p.m. Excuse me.
Thank you. Nothing further, Judge.
Nothing further on.
Is there a photo of that console area in the evidence?
There is, that was exchanged, I would have to, I don't know about what's back there, I don't know.
That photo is back there?
All of the photographs are with the jury.
Oh,
No, we have a lot of photographs that didn't get admitted.
Yeah,
And
okay.
there are hundreds of them. If the court wants to look at those.
Judge, the other thing that could show, we didn't know how you want to deal with this, but I mean, we have the photographs of what had been discussed and here in this hearing that may not have been entered in evidence originally because we didn't know they were.
mm-hmm, mm-hmm.
Any more significant than the ones that were.
What was the seatbelt configuration of persons who were wearing the seatbelts at the time of the wreck? And the right.
The driver was wearing his in the Nissan, the right front passenger, the right rear passenger, and Miss Lindsey was not.
Mm-hmm.
So we have 4 people in the car, driver was only one wearing.
The driver was the only one wearing.
The one that was wearing.
Oh, okay. What does the console look like? Is this just like a standard automatic transmission with sort of a bucket seat type or a bench seat?
Yeah, I'm not 100% sure. I can't recall
Mhm.
if it had a armrest or what. I'm not sure. I know that there were inspection photographs that we took, and you could show that.
Your Honor, we have the black and white thumbnails printed already that we could give Your Honor to look at.
Okay, that'll be fine for purposes of this hearing.
I'll show the
Your Honor, we can be hooked up. The in-house system. We have this with photographs on.
Or you could play it on theirs. Theirs is ready to go, I think.
Judge, we'll get the disc on in the meantime. These are the photographs of the Nissan.
You better come up and take a look at it.
Judge, I'm sorry, my computer had to restart.
Oh, okay.
We're gonna check, one of the computers should be hooked up, I think. Judge, these are the color thumbnails of all the photographs taken of the Nissan vehicle.
So if there's a number you'd like to see better, if you just tell me the number in parentheses, I'll be able to get to it and make it larger.
Okay,
That
number,
on scene or the next day?
That's the next day. This is the,
Can we see the on scene?
I think this is what he was asking about. I'll put on whatever.
let's try 350, 356, 42. Okay. Okay, let's go over to 43. And 44. $45. $48. $81. $97.
Your Honor, these photos were the photos taken the next day or 2 days later
Mhm.
at the inspection. We also have the on-scene photos. If Your Honor would like to see those.
Do you have one with the, let's see here. Yes, how about number 7? would the physics reject the idea that a person flew out the back glass?
It is possible. As the car struck, the car essentially is going to move up under the occupants. So inertia is going to keep them here. As that car's hit, the body's going to go toward the force first. At the point of impact of the rear axle, as that car struck, everybody's going to go toward not so much exactly the troll car, and that's because the car has motion too. It's going to go off an angular. So everybody's going to go, if we're sitting in a car, kind of towards your right and forward. Okay? Because boom, that's the way the car is moving away from them. That would shift everybody toward that right to front right.
But then that becomes pretty unlikely if a person is largely in the front for that to occur, perhaps.
Well, you have somebody up front that's in a higher seating position or higher area, as they seating position higher than the seat is itself. As it moves forward, they go out to move.
Whose pocketbook was in the front?
There were a pocketbook. I don't know who it belonged to. There was a pocketbook.
Nobody investigated that?
But there's a picture. There's two pocketbooks. I remember a picture of two pocketbooks.
Okay. That's all I have.
If I may, relative to the pocketbooks, there was, I think it was, on scene they were in different places.
Okay.
We can show the on-scene photos if necessary.
Okay. Have you got that on scene photo?
We can bring the thumbnails to Your Honor. We can start with on scene Trooper 604. There's two sets of on scene photos. This is the for 604. We'll pull those up.
All right, so number 18 maybe? What, okay. Number 19. And this is the on-scene photos, is that right?
That's correct, Judge. Your Honor, these were taken after the victims and I believe Mr. Scott had been taken to the hospitals, and after some scene cleanup had been performed.
But nothing is disturbed in the car, is that right?
Well, in Your Honor, if I could show Mr. Pilgrim this first. Judge, if I may approach, this is Mr. Officer Alexander, Sergeant Alexander. He was one of the first on the scene. This gives a description of where he located items.
Okay, I don't have anything else. Any other questions?
Nothing to say.
Yeah, we do, just based on some of the photographs that were entered.
You testified earlier to the phone. We discussed this with some colleagues of yours. What in these photographs that we're going to look at would lead you to believe that she was in the front seat or somewhere beyond the front seat? Is there something particular, or a couple things?
Yes, sir.
What were?
The impact itself, due to the momentum of the car, the momentum of the Nissan, and the momentum of the Dodge, when they're struck, they're going to go, like I said, toward that right front side of the Nissan. So everybody's going to move that way. There is no indication that the back seats of this car have been struck or loaded on by a body. So as
Slow down and tell me that again.
there's no indication of the two front seats that you're seeing. You're looking at the passenger seat and the driver. There's no indication that a object, being a person, loaded forward and struck those seats. Normally, in my training, I see that experience. They're hit and actually bend forward. That's a lot of momentum. There's nothing to indicate that. Also, the door, the passenger door, has some outward loading or inward loading going out, which would indicate that something loaded against that. I realize there is a person sitting in that right front seat, but the loading is to the top window, which makes me believe that if something goes out that window, it's slightly higher than the seated position of the seat. Meaning where someone is either leaning over, sitting on the console area, somewhere in that front area higher than the seated position.
Also, is there anything about the blood on the windows or anything that?
No, sir, we did no test on any blood at all.
And the rear left window, it was in fact left intact, was it not?
The left rear, behind the driver rear, I believe so, yes. Yes, sir.
That's all I have.
Were you able, did you look at the Snapchat matters?
I looked at the video, yes, sir. I don't know who retrieved those videos. I looked at them, or looked at the one, and it was a very dark video. Just the lighting was real dark. We looked to see if we could enhance the lighting on it to see if we could see where everybody was sitting. All I could tell was Ms. Lindsey was videoing, and there was somebody, a male, in the video also, and that the car was stopped, but I couldn't tell you exactly where they're sitting in the car. The video just didn't show that.
Do you have any time relationship to the videoing and the crash?
Like when that Snapchat video?
Yep.
No, sir, I do not. I'm sorry.
You said people were videoing in the car?
It appears that Ms. Lindsey took a video maybe with her phone, and that's the Snapchat video that we have.
Mm-hmm.
But it appears in the video that the car's not moving. It's almost like that they're stopped somewhere, parking lot somewhere.
Okay. Okay, any other questions?
No, Judge.
Okay. You can step down.
Thank you.
Thank you.
Y'all have to be excused as well.
You're excused.
Thank you, sir.
Darn, with regards to motions, we have no further witnesses. We just reserved closing argument.
Okay.
No,
Go,
this is just argument.
go ahead.
Your Honor, we have stacked the case off. Judge, I'd like to begin with what Brady material is. And simply put, Brady material is exculpatory information that could lend to a change in the jury's determination of guilt or innocence. In Jones v. Medlin, 302 Georgia 555, on page 4 of 7, Your Honor, we have highlighted, to prevail on a Brady claim, appellants must demonstrate the prosecution willfully or inadvertently suppress evidence favorable to the accused, either because it's exculpatory or impeaching. However, the Constitution is not violated every time government fails or chooses not to disclose evidence that might prove helpful to the defense. Brady comes into play only when the suppressed evidence is material, i.e., only if there is a reasonable probability that had the evidence been disclosed to the defense, the result of the proceeding would have been different. A reasonable probability is a probability sufficient to undermine the confidence in the outcome. Your Honor, in Eli v. State, in the highlighted portion, the Supreme Court has explained a Brady violation thus: where a prosecutor suppresses evidence favorable to the defense, the state violates the defendant's due process rights. The defendant bears the burden of showing, 1, the state possessed the evidence favorable to the defense; 2, that the defendant did not possess the evidence, nor could he obtain it himself with any reasonable diligence; and 3, the prosecution suppressed the favorable evidence; and finally 4, that had the evidence been disclosed to the defense, a reasonable probability exists the outcome of the proceedings would have been different. Your Honor, the other cases that we go into, Usury, USSERY v. State, 195 Georgia App, says mere speculation of the items the appellant wishes to review possibly contain exculpatory information does not satisfy the defendant's burden. Albert v. State, 180 Georgia Act, 779. The fact that it very well could have created enough doubt isn't enough. That is speculation. It's insufficient to invoke a Brady violation. Brady cannot be read as requiring that as a matter of constitutional law, everything must be disclosed, which might influence the jury. Your Honor, these are the broad statements of the Georgia Supreme Court and the Court of Appeals. We believe that in this case, none of this was material, none of this was relevant, and therefore it cannot be exculpatory. And the primary reason we say that is, in a case such as this, it is a strict liability offense, and with the proximate cause, the Georgia Supreme Court has held a victim's negligence, any victim's negligence, is irrelevant and cannot be considered. In Basinger v. State, 257 Georgia Act 273, the court held, unlike the civil context, in the criminal context, it is simply not relevant that the victim was negligent unless the defendant's conduct did not substantially contribute to the cause of the injury. In Basinger, the driver of the vehicle challenged that the fact that the infant was not in a rear-facing car seat was the contributing factor, that the infant was in the wrong kind of car seat facing the wrong direction. The Georgia Court of Appeals held that's not relevant. That doesn't go to the jury. That is excluded. In King v. State, the court held the same thing, quoting Basinger. Unlike the civil context and the criminal context, it is simply not relevant that the victim was negligent. Mitchell v. State holds the same. McGrath v. State holds the same. Whitener v. State holds the same. Your Honor, the courts have held time and time again that the actions of the victim are not relevant. If the Georgia Supreme Court and the Georgia Court of Appeals have held that the actions of the victims are not relevant, it cannot be said, for purposes of Brady analysis, that they're relevant and material. It wouldn't add up. Where proximate cause is the standard, as here, court, such as in Hartzler v. State, Hartzler 332, Georgia Act 674, has held the proximate cause as well as the cause and fact of the death is the question is that the defendant's conduct. An injury or damage is proximately caused by an act or a failure to act whenever it appears from the evidence that the act or the omission played a substantial part in bringing about or actually causing the injury or damage, and that the injury or damage was either a direct result or a reasonably probable consequence of the act or omission. Further, what constitutes proximate cause is undeniably a jury question and is always to be determined on the facts of each case upon mixed considerations of logic, common sense, justice, policy, and precedent. This same principle is held in Hamill v. State, Harrison v. State, McGrath v. State, Ponder v. State, and many other cases, Judge. What I think is important is the question for the jury in this case is were the actions of Mr. Scott the proximate cause of the deaths of Isabella Chinchilla and Kylie Lindsey and the serious injuries to Dylan Wall and Benjamin Finken. It is a question of did his speed and did his recklessness play a substantial role in causing those injuries and those deaths? That is the question for the jury. Where Ms. Lindsey may or may not have been sitting in the car does not go to that question. It does not answer the question of does his speeding and does his recklessness cause those injuries or cause those deaths. Therefore, it cannot be material and it cannot be relevant. Once that analysis is done, there is a second prong to the Brady evaluation. Did the defendant exercise reasonable due diligence? Could they have found this information out? Trooper Stone and Sergeant Barrow indicated they were never contacted by the defense. In fact, Trooper Stone said until he was on the witness stand, that was the first time he had ever spoken to Mr. Pilgrim. We were set for trial in March. We were set for trial in May. This case has been around since 2015. Never once did they exercise the diligence, the due diligence, the reasonable due diligence to call Trooper Stone and say, what are you going to testify to? They were provided a disc that said Trooper Stone, Trooper Brandon Stone, wouldn't have this enhanced. Never once was a phone call made to say, Trooper Stone, why did you have this enhanced? We hold that it is immaterial. We hold it as irrelevant. But even if it were relevant and material, a burden is on the defense to exercise due diligence. This was not created by the state. It was not, by the DA's office. It was not requested by the DA's office. And this was a speculative theory of the Georgia State Patrol. Both Sergeant Barrow and Trooper Stone testified they cannot say when Miss Lindsey moved to that front compartment or what portion of her was in that front compartment. They indicated that based on, they believed that she went out the front passenger window, and they believed watching a video that they saw a blonde or light blur or blob in the front passenger area that they took to be her because she was the only blonde-headed individual in the car. That's what the speculative theory is based on. That does not rise to an expert opinion or an expert theory that is relevant or material to this discussion. Your Honor, it is not for a witness to invade the kin of the jury on identity. The court has held that identity is well within the kin of the jury to watch a video and identify who's in it. And it's not for someone to testify. Now, this is a little bit different. We acknowledge. This wasn't looking at a picture and saying that was this person. But it's the same principle. It is well within the kin of the jury to identify if they see a human head in a window. That is We have all seen a human head, we have all seen a human head through a window. And I believe it is well within the ken of the jury to make that discussion. Therefore, Trooper Stone would have never been allowed to testify to that at trial. It would have invaded the province of the jury. Trooper Stone could not have testified that he thought he saw a light blob in a video. So not only is it speculative about how she got there, when she got there, what portion, if any, of her body was in that seat, he wouldn't have been allowed to testify to it. Therefore, it is immaterial, irrelevant, would not be admissible. These are the questions we have to ask in a Brady analysis. The state turned over the enhanced video. We turned it over within the timeline required by law. Your Honor, in reviewing and preparing for this case, I went through every pleading that we had in our file, and I believe there was some 10 plus discovery notices where when we got evidence, we turned it over to the defense. We turned over everything in our file. We have tried this case to the best of our ability with justice in mind. We recognize the rights of Mr. Scott, and we recognize the rights of the victims. That is what we push for. We aren't looking to win by any means. That is not why I became a lawyer. That's not why Ms. Myers became a lawyer. That's not why Mr. Cranford became a lawyer. Your Honor, I have appeared in front of you over the last 10 years in civil practice and in prosecution. And that has never been my goal to win by any means. That is not why we, the profession of lawyers, enter into the field of law. This is a case where a speculative theory was proposed, and we made a determination that it was not exculpatory because of its speculative nature, its inadmissible nature. And we turned over the video, we turned over the evidence, and told the defense where we got it from. We told them we got it from Trooper Stone, that he enhanced it, where he enhanced it, giving them the opportunity to ask Trooper Stone any information they wanted about it. And not once was he contacted. Your Honor, we have a situation here where this information came to light on Monday evening. We sat in this courtroom from 9 a.m. until nearly 6 p.m. yesterday. Never once was this raised. I understand that Mr. Pilgrim wanted a little more information, but we had a jury making deliberations. Had they come to verdict, we would be in a nearly impossible posture. Mr. Pilgrim sat on this information until 6 p.m. last night. We were notified around 8:30 last night. And we spoke to Mr. Pilgrim and Ms. Griffin this morning about this, and we told them, as we tell the court now, we see no violation, Judge. We told them the same reasons. I don't see that this could change the outcome of this case, because it is not for the jury to consider any negligence, if true, for the jury to consider any negligence on the part of any victim in this case. The case law is clear. We argued it in closed. Your Honor told us that we could argue it in closed because it is the law of this state. So we ask that you deny the motion. You find that there is no Brady violation. And we bring the jury back and we allow them to continue to deliberate to a verdict in this case. Thank you.
Your Honor, I guess with regards to Brady, we have to kind of start at the beginning. We have what has been marked, and it's already in the record, Your Honor, but it's our discovery demand. It's marked as B1, just to keep it clear. It's a discovery demand, Your Honor.
No objection, Judge, if it's what's been filed with the clerk.
It's B1, Your Honor. And what it is in that particular discovery demand, subsection B that we filed back in 2017, we request all material that may be arguable under Brady that, in fact, is evidence or might lead to evidence. We argue that, we asked for that in section B of that particular discovery demand. So the state, as far as being on notice of what we wanted, what we asked for, that is clear. Your Honor, B2 we've marked, this is the certificate of service along with a copy of the disc and a brief statement of what is on that enhanced disc. Your Honor, that statement, and I made a point to ask the troopers if they wrote anything, if they reported anything, if they memorialized anything, and each one of them said no, they did not. That leaves only the district attorney's office to memorialize that note. If you look at that note, it does mention Trooper Stone had taken that video to the Griffin Film School in Griffin Technical College, and they had been enhanced. But what is missing, and is conspicuous by its absence, is any discussion about this 2-hour meeting that they had with both Trooper Stone and Trooper Barrow about the possibility of a front seat passenger being Miss Lindsey or sitting in someone's lap. That is never mentioned. Also, the player that is required to watch this was never mentioned, that you must download that. So, and also notice when that video was served upon the defense was the 2nd day of May in the afternoon. And Your Honor, that was, again, within 10 days of this particular trial beginning, but it was also some 45 days after the state had received it. So, when we talk about sitting on evidence, there's a piece of evidence that they in fact chose to sit on. And the reason I waited a day, Your Honor, is, and I was in court on it yesterday, is I wanted to confirm before I blew this whistle that in fact it was something that should be done. I wasn't taking it lightly, I didn't take it flippantly. I decided that if before I did this, before I made this allegation that the state failed to give it to me, I wanted to be certain. So I didn't find out till late Monday, throughout the day yesterday, into Monday afternoon, or Tuesday afternoon, when court was released, we confirmed it from both the troopers. Now, Your Honor, with regards to Brady, and that's our first argument, as regards to Brady, we must look whether it's relevant to guilt or punishment. I think here it's very relevant to guilt or punishment. With regards to guilt, particularly the state has chosen to travel under this proximate cause argument. And they're arguing that if our client was substantially responsible, and thus the proximate cause of the injuries or the deaths of the victims, and the death's negligence is somehow negated. However, Your Honor, if the negligence is such that it creates a new violation of the law, i.e. obstructed driving, distracted driving, then I think that is something the jury deserves to know about. And I think that's something, it is directly material as to who caused this collision. The state's theory is solely, and has been solely, that Mr. Scott's speed caused this collision, and nothing else, and you, as you can tell by the behavior, nothing else was going to get in the way of that theory, whether it be true or not, whether it be something one of their own witnesses, their own experts, told them. They disregarded it and they buried it. And if you look, Your Honor, we've got some cases that we've given you copies of already. We also cite the same Jones v. Medlin case, that's M-E-D-L-I-N, 2017 case in the Georgia Supreme Court. And in it says that to prevail on Brady, appellants must demonstrate the prosecution willfully or inadvertently suppressed evidence favorable to the accused, either because of exculpatory or impeaching. Well, Your Honor, let's look at this to begin with. There's no doubt it was willfully done. They told you they willfully did. They told you it didn't matter. They told you they have set the Brady standard in this court and in this county, in this circuit, and this didn't matter. That's what they've said to you. Not that it didn't exist. Not that they said it didn't matter because it's not Brady. Doesn't matter. Well, Your Honor, we go on and we cite a couple other Brady cases for you. One of which is Giglio versus the United States, the Supreme Court of the United States case from 1972. And in that case, and it's still good law, that's G-I-G-L-I-O, and I've followed with that name since I looked it up, so I apologize. But it says, deliberate deception of a court and jurors by the presentation of known false evidence with rudimentary demands of justice. The same result obtains when the state, although not solicited false evidence, allows it to go uncorrected when it appears. In this case, Your Honor, they were testifying, and they did not try to reconcile this on the stand. They could have done so. They chose not to. And Your Honor, it says here, whether non-disclosure is a result of negligence or design is the responsibility of the prosecutor. The prosecutor's responsibility to bring it out to court, not the defense burden, not shifting a burden. Your Honor, also would bring to the court's attention a case called In the Matter of Lee, that's L-E-E, May the 1st, 2017, Supreme Court of Georgia. And this is as well as a Brady issue, Your Honor, but in this particular case, and it had to do, this case was, again, it was a child molestation case. But it says here, it says that the Georgia Court of Appeals says the prosecuting attorney can rectify Brady by having it delivered at trial, the information delivered at trial, which thus gives the defense a chance to cross-examine. However, the court goes on to say that the duty to disclose is when a prosecuting attorney delays disclosure of exculpatory evidence until trial, they play with fire. Whether delays disclosing such evidence violates Brady is a question that requires consideration of numerous circumstances, which we'll bring up before the court, many of which are unknowable for the prosecutor until the trial is underway, and some of which is unknowable until long after the trial is concluded. A prudent prosecutor would disclose exculpatory evidence as promptly as reasonably possible. In this case, not only did they not disclose it at trial, they kept it for 45 days when they knew it was possible, and did not mention it to the defense. We also cite a case out of the Third Circuit Court of Appeals, and it's Roderick, R-O-D-E-R-I-C-K, last name of Johnson, J-O-H-N-S-O-N, versus Louise, L-O-U-I-S, Folino, F-O-L-I-N-O. And in this case, Your Honor, this was a habeas, which was granted in federal court, which almost never happens. But it had to do with Brady violations. And in this, it is cited, Your Honor, on the second page, looks like the notes number 7, that the prosecution has an affirmative duty to disclose any exculpatory or impeachment evidence to the accused, even though there has been no request for that evidence. In this case, there had been requests, but even if there hadn't, they still have a duty. It says, in order to comply with note number 9, in order to comply with Brady, the individual prosecutor has a duty to learn of any favorable evidence known to the others acting on the government's behalf, which means the officers. In this case, they not only had a duty to know, they did know. They were told. And they were told by the troopers in a very lengthy interview, not in passing, not something that was sent via text, not something that was sent in a Skype video, but they were told directly in an extensive meeting. Now, when looking at this, a reasonable and profitable of it, is this material, if it's decided it's Brady, then you have to decide, well, what would happen if this evidence would come in? A reasonable probability of a different result as required to demonstrate materiality under Brady is shown when the government's evidentiary suppression undermines the confidence in the outcome of the trial. Well, that has definitely happened here because there's a lot of questions that would have been asked by myself of Mr. Finken, of Mr. Long, of Mr. Alexander, of Mr. Wagner, of Mr. Lambert, of Mr. Sparks. A lot of questions would have been asked, also of the troopers by myself, and I think that in fact does undermine it. It says here, inadmissible evidence may be material for Brady purposes if it could have led to the discovery of admissible evidence. So whether it's actually admissible itself is not the test. The test is it admissible, or it could have led to admissible evidence. That's the test. The state wants to tell you it wasn't relevant. We didn't think it was relevant. It's still not relevant. We did nothing wrong. Your Honor, that is just not true. Because in fact, the evidence, if it could lead to admissible evidence, that is the test. Your Honor, I think this is clearly a Brady violation. This is evidence they knew. This is evidence they did not bring forward. Not only did they bring forward, they almost did a cloak and dagger type of approach. Hey, wink, wink, nod, nod, we'll give them the film at the last minute. Let's see if they can watch it. They don't give us the player. Don't tell us how to play it. They don't tell us the subject or the nature of the conversation with the parties who created it. Also, Your Honor, they are advising their troopers not to speak to me or my office without them present. Truth, to be fair, did not call Mr. Stoney. You know why? Because lead investigator was Sergeant Barrow. He's the troop sergeant. I called Chad. Sergeant Barrow is as a local lead investigator, and that's who I called. And he was told to me that he was encouraged to only speak to me with the DA present. If that doesn't smack of attempts to keep evidence from getting to me freely and getting to the defendant and maybe favor him, I don't know what does. That's an attempt to control the narrative of what that was. Because Jed Barrow's 6'3", he's got a gun. I don't know what I could do to it. But apparently the state thought I could do something. And they encouraged him not to talk. And they encouraged him not to share it. Granted, could they have? Yes. Did I push Mr. Barrow? No. He's 25, 27 years of state patrol. I'm not looking to get him in trouble with his higher ups. I'm not looking to get him in trouble with the DA's office he deals with. I had his skirt team report. I had his findings. I had his EDR. I didn't think there was anything more to it. You know, that moves on, or an argument. That's our first ground for mistrial. Yes. Our second ground, Your Honor, is the discovery statute in the state of Georgia, which is 17.6.4. And in that statute, Your Honor, we look at subsection 4. Make sure I get this right. It's actually B4. And Your Honor, it is clear in that statute that the state in the prosecution is required to turn over evidence in this case, and they're required to do it 10 days prior to. And it says that if the report is oral or partially oral, the prosecuting attorney shall reduce all relevant and material portions of such report to writing and serve opposing counsel with such portions no later 10 days before trial. Clearly marked in the code section. Now, that letter that you have in front of you, that accompanied the disc and accompanied the certificate of service. Nowhere in that document that was created by the district attorney's office did they do what was required by the statute. No way did they actually reduce all relevant and material portions. Again, they feel as if the fact that she may have been sitting in the front seat in Mr. Finken's lap, or sitting between the two seats, that she may have been sitting in a higher elevation in the other seat, that she may have come out the front passenger window, that's not relevant to them. That's not material to them. Thus, they think that portion does not apply to them. That what they reduced is all they had to reduce. And what they gave us is all they had to give us. Again, second grounds is we think they in fact violated the discovery statute. Thirdly, Your Honor, State Bar 3.8, State Regulations, Rules and Regulations 3.8, subsection D of 3.8, make timely disclosure to the defense of all evidence of information known to the prosecutor that tends, it's a big word, tends to negate the guilt of the accused or mitigate the offense. Tends. Now, Mr. Swope got up here and talked about that he could not prove it. He did not know certainly. There was no way to prove it beyond the reach. It says tends. When you talk about invading the province of the jury, that evidence is something the jury should know. That Mrs. Lindsey could have, in fact, and was believed to be in a different location in this car. That's a evidence, in my opinion, that's information that tends to negate. Now, Your Honor, when we received this information, just for the record, we were in the middle of, and I say we, me and Mr. Griffin, my co-counsel, we were in a trial in Douglas County, State versus Christopher Hedgecock was the trial's name. And we were in the middle of a trial there when we got notice that this particular disc was delivered to our office on the 2nd of May. Mrs. Griffin,
this disc being what again?
The disc that is referenced in B2, Your Honor.
And that,
the enhanced disc.
Is that Snapchat?
The Snapchat's on that is part of that video as well, yes, Your Honor.
Okay.
It's part of it.
So let me ask you again. This that the patrolmen have testified about the potential blonde head comes from the Snapchat. Is that correct?
No, sir, Your Honor.
No.
It comes from their review of the, at least, I don't want to put words in Trevor Stone or Barrow's mouth, but it comes from the review of the video, the positioning of the body.
The dash cam video.
The dash cam video. Stage 32.
Okay.
It comes from their review of the video, review of the evidence, the review of, as he mentioned, talk about inertia, body motion, tend to stay in motion, direction, travel, kinetics inside the vehicle, all those sort of things is what he believed. That's where his theory come from, that she was sitting in that seat. Yeah. Well, and the video, Your Honor, the video that the trooper had State 32 that was introduced. That's his regular dash cam video. Trooper Stone went back on his own and attempted to enhance that video because he believed that there was evidence of where Mrs. Lindsey's body ended up and the way the car was, the photographs, and the lack of evidence in the car that she was ejected any other way than from the front passenger side, that he thought, okay, she's the only one who's ejected. She came out that window. How did she get out that window and not tear up the seat? And that's what we heard her testify to. So what they served us on May 2nd, Your Honor, was the enhanced video from the school in Griffin. And Ms. Griffin, being thorough as she is, she then calls the state next day and asks them, what is this? And we were advised that this is just something the trooper did on her own. We didn't ask him to do it. It's nothing of relevance. We don't plan on using it. That's what we were told. Even though, in fact,
say what you just said again.
Your Honor, we called on the 3rd of May, and I can have Ms. Griffin actually testify to this if you wish, Your Honor, give this statement. But we called the state, we called the DA's office, and we were told that video was an enhancement that was done. It was a lightning. If you notice the language in the note, B1, that the video had been lightened. And in that lightning, that's all that had been done, and it had not changed anything, and that they had not intended on using that video, and there was no value in what he had done. That's what we were told. And that's what we were told by the state, and that was the day after we received the video. And Ms. Griffin can actually, and I was going to let her finish, Your Honor, tell you exactly how that went, because I was not present for that, so I don't want to do that with her being present. She can tell you exactly what the conversation was. Go ahead, Greg.
My understanding of that conversation, Judge, I called the state the next day, it was after business hours, and Mr. Miller that I've got trying to review that video. And when I got to speak for the state, I asked them, what is the significance of this video? And they said, there is none. They said, we don't know why they did this. They didn't do it our direction. We don't plan to use it. It's not relevant. Don't worry about it.
When did you receive the summary?
With the attachment. So we read that night when Mr. Pilgrim and I came back to the office after we left Douglas County Courthouse. It was after hours, and so the state's office was not open. So I had been notified that day while we were in trial that there was evidence that had been delivered in this case, which we obviously were not expecting because we understood when we came to motions on March 18th that we had everything. And so when we got this information, we came back to the office specifically that night with the intent to go through it. We could not open the photographs and we could not open the video. And so I called the next day and I asked the state, what is the purpose of this? Because I can't access these images. And I was told that they didn't know what the significance was. So our contention in that, Judge, is that was another, that they'd already provided me a writing that didn't disclose it. And it's, I believe, under the discovery statute, required that because these people were the accident reconstruction, the prosecuting officers in this case, that it had to be reduced into writing by the DA's office, because they are the prosecuting attorneys in this case. They had a duty to reduce that to writing and provide it to us. And they knew they had a duty to provide something because they did. They just left out the part that would be the most pertinent and relevant to our defense.
So, go over with me again. You called the next day?
Yes, Judge.
And you asked the significance of this?
I asked what the significance of this video was, why we got it.
And the reply to you was?
I don't have it. I would be completely candid with the court. I did not have it written down verbatim.
Mm-hmm. Okay.
But I went and talked to Mr. Pilgrim right after. And I was told by the state that there was no significance to this video, that it was not done at their direction, that they didn't know why the troopers had done it, that they did not plan to use it, it was not relevant, and not to worry about it. Because I was letting them know I couldn't play it.
Okay.
Your Honor, that goes to our third.
Hello?
That goes to our third.
Just a second. Prosecution wants to say something.
When the time is appropriate, as we believe that is new evidence and not just our. Ms. Myers, who's on the other portion of that phone call, would like to address the court.
All right.
We can reserve until Mr. Phillips.
All right.
And Your Honor, that concludes, that is our third prong of our request for a mistrial in this matter. And we would ask that the court, when declaring this mistrial, do so not only for the Brady violations, but do so for a violation of the discovery statute, and do so for prosecutorial misconduct according to 3.8 subsection D that has been elaborated on by myself, by the witnesses, and by Mrs. Griffin before this court is hearing. And we ask that that be the room of the court, that it includes that language of why the court is in fact mistrial. Thank you.
Go ahead.
And Your Honor, much like Ms. Griffin, I obviously did not verbatim record our conversation. However, my recollection of the conversation was she asked why it was done, and I advised her truthfully. I don't know why the troopers did it because we did not ask them to do it. However, I did advise her when she asked specifically regarding the Snapchat images, because on that disc, the Snapchat still frames, there's probably 900 still frames. It looks as though the Snapchat video was broken into every single image frame and put on the disc. And she asked if that was this Snapchat video could be played. I advised her, in my understanding, it could not be played because the Snapchat video was not on that disc. It was just the frame by frame that had been lightened. I advised her that the state was not going to use the lightened enhanced dash cam video because, in my opinion, it showed nothing. We had future conversations at meetings where they conceded and agreed it showed nothing. And that is my recollection. I have no recollection of ever telling Ms. Gribbin that she didn't need to worry about a piece of evidence. That's not my responsibility, and I would never deign to advise them what they should or should not worry about in regards to evidence. But my recollection of that video specifically focused on the Snapchat frame by frames, of which there were 900 and something images, and they actually asked, I believe there's additional videos on that disc of the students at Southern Crescent, Georgia, and they asked if those people are involved in this case, and that was at a later meeting, to which we said no, those are videos from something completely unrelated as far as I'm aware.
Okay.
Your Honor, just in responses, we have heard, and I will close. Ms. Myers, just make
Let me take a 10-minute recess. I'll let you close, and I'll also give some thought to whether I have more questions.
Yes, sir.
Jesus. Didn't know.
You got the worst of it.
Yeah, I guess it's going on after the meeting.
Well, now, that's what does my. Court will come to order.
Go ahead.
Sorry, Your Honor. Nothing further on what the court decide or inquire how we wish.
Could I have the document summary that you gave me before? Is that in evidence that I just had just before about the pocketbooks?
No, sir. We'll get that back out. This is the incident report written by Sergeant Alexander from responding to this event.
Give me a copy of that. Would that be stipulated facts for purposes of this hearing?
State has no objection.
Got no objection. Officer testified. Obviously, we didn't in his report because it was testified. But we didn't object to it, so you can make a decision based on that.
Okay. Thank you. We'll reconvene at 1:30 today.
Thank you, Judge. And Your Honor, we designated the exhibits for this hearing as B-number. So I think with that one, it would be courts B-1 would be the appropriate way to denominate it so that
Courts B1. Is a document with the stamp date 9/27/15, right?
Yes,
That
sir.
is the date of the entry.
Yes, Judge.
Is that more? Yes, sir. Is after midnight.
And Judge, that is the narrative portion of the incident report of Sergeant Alexander who testified in this trial.
Okay. Okay, thank you. One-third.
They're going to need a microphone back.
Huh?
The microphone back to cut it off or anything, or you got to run all that?
Yeah, go ahead.
Bring it back.
Bring it back. I'll cut it off. I'll put new batteries in it. I think one.
If it's a desktop.
Thank you, sir. Appreciate it.
We'll lock it.
We'll lock it. Okay. We'll lock it.
Hey, Vinny, this is Alan out here in Carrollton. I'm going to shut my camera down for about a half an hour. All right? Thank you.